Senate Judiciary is in session. The Honorable Senator Auschler is going to do the pledge for us. To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Senator. It's you. You're up half the day, I think. Senator Auschler is going to introduce SB 269 for us. Welcome, Senator.
Good afternoon. Thank you. Thank you, Mr. Chair. Thank you, committee. For the record, my name is Senator Deborah Auschler, representing District 24, the towns of Exeter, Stratham, Greenland, Rye, Hampton, Northampton, and Hampton Falls. Today, I am introducing Senate Bill 269, which was requested by the Secretary of State's office to make sure that the law that we passed last year and is in effect that bans child marriage, that the language changes the terms bride and groom to applicants, and that the lines 8 and 9 cross out the waiver, and lines 14 and 16 are 16 and 17 are removed from a reference statute. So I won't use the H word, but it is a bill to clean up some language so that everything, the ducks are in a row. So like I said, this was at the request of the Secretary of State's office. It's not a policy change, just some language cleanup. Happy to take questions.
Thank you very much, Senator. Seeing no questions, rejoin us up here.
Thank you.
Kristen Martino, I think it's Martino. Good afternoon, ma'am.
Good afternoon. Thank you for recognizing me. I'm Kristen Martino. I am the Registrar and Director of Vital Records. And thank you, Senator, for presenting this bill. This is, as she was saying, just to clean up some language on our statutes after the passage of last year's SB 359. As you know, the minimum age of marriage was raised to 18, and statutes concerning court-issued aid waivers were done away with. So there was some language that still existed within our chapters that made reference to those. And I also discovered in reviewing that we were still referencing time waivers, which were done away with in 2006. So we are looking forward to removing that from our statutes as well. And I am here if you have any questions.
Thank you very much. Seeing none, you have a great day. A motion to go into executive session.
Second.
All in favor? Aye. I have an ought to pass motion on 269. Do I have a second? Any discussion? All in favor? Aye. Second by seconded. All in favor? Aye. Senator Auschler, you want to take it out? Sure. Great. Thank you. Okay, we got a few minutes to go. I do.
Motion to come out of executive session?
All in favor?
Aye.
Aye. Thank you. Senate Judiciary is back in session. Senator Prentice is going to introduce 265 and help me understand why she wants to repeal provisions in the religious use of land and structures. Senator Prentice, welcome.
Thank you, Senator Gannon and members of Senate Judiciary. For the record, Sue Prentice, Senate District 5, 15 communities in the Upper Valley, a few in the wonderful Sullivan County, and one in Merrimack County, the beautiful town of New London. I am here to introduce, as you said, Senate Bill 265, revealing a specific provision that was implemented in 2022, RSA 674-76, relative to religious use of land and structures. Here's why I want to do this, Senator Gannon, and in no way is this about trying to infringe on anyone's right to practice their religion or free speech. But what we have here is a case of usurping local control, saying that, according to the statute as written, that no zoning ordinance or site plan review regulation shall prohibit, regulate, or restrict the use of land or structures primarily used for religious purposes. Now, they have to be constructed in a way that aligns, if they're in a particular neighborhood, is not too big, meets certain setbacks. Like it would look more like the other structures in that neighborhood. But for me, the issue becomes that communities, including my wonderful city of Lebanon, already have zoning ordinances and already work with and regulate either as a primary provision or by special exception where religious structures can be built. And I think that preserving the character of our neighborhoods as determined by local zoning ordinances is important. And this has nothing to do with housing. So if we're talking about housing, it would be a different conversation. And again, I'm not looking to infringe on anyone's rights to practice their religion. But in looking, some constituents brought this to my attention, and looking back on the history of this, this evolved in 2022 out of a dispute in a community that had to do with where to hold home prayer groups. So there were groups trying to assemble in their neighbors' homes for religious activities, for prayer groups, or for Bible study. And there was concern raised, and I believe that Bedford was the primary community, but this has come up in other communities as well, that they were, and this quote unquote by Rep. Kurt Welper of Stratford, New Hampshire, that they were having problems with local land use officials about the number of people they could have in their house for a prayer meeting. So it strikes me that having a number of people in your house for a prayer meeting and saying you can build a religious structure anywhere you want, regardless of any local zoning, that this is like, those are extreme ends. I feel like that there is a middle on this, and in reflecting on this early this morning, I thought, well, wouldn't it be nice if and proper came with what the middle ground was? I mean, I could prepare an amendment that would put a time-sensitive study group in place to look at what this middle ground in terms of how to, as we should, accommodate these, prayer meetings and and what people want to do within their homes and within their neighborhoods if it's home-based. But I have great concern about usurping local control in this particular area. So that is why I am here today. I do have one particular community that has been, working on this and deeply at odds, and that is the town of Hanover. But I know that this has come up in other parts of the state, and that's why I'm here. So I'm happy to answer any questions you have. And again, I think these are extremes. I think there's a middle ground, and I'd be happy to work on the middle ground, but I don't think we should be usurping local control in this when you can already build a religious structure in areas that are zoned. Thank you.
Thank you very much. Questions? I can't believe we don't have one, but no, you're lucked out. Thank you, Senator Prentice.
How is that possible?
I don't know. It's an interesting topic, and I'm thinking both ways. So
Yeah, and again, I would, if there's a value in developing a middle ground, like a study committee, or trying to find a way to narrow this down, I would be totally open to doing that. I just, again, I think that these are two extremes, and we've got to come somewhere in the middle.
Thank you, Senator.
Thank you, Senator. I think we have a few minutes before the next hearing.
Dennis, how do you say your last name? I'm sure there's only one Dennis here. Can't be Denise. It's got to be Dennis. Talahustic? No. We'll come back to you. Michael Tierney. You got lucky, Mike. Easy name.
Good afternoon. My name is Michael Tierney. I'm an attorney who practices in the area of land use. Particularly, I've had over 50 clients of various religious churches, synagogues, as well as a temple. And I've assisted them in obtaining land use approvals, either for additions or for new constructions. I was one of the people who had asked Representative Wolper, who's here with us today, to bring this bill back in 2022. And there were lots and lots of churches who had been discriminated against by particular discriminatory zoning ordinances. It wasn't just limited to the prayer group in Bedford. One of the areas where this happened quite harshly was the town of Hanover. The town of Hanover has not approved a new church in my lifetime. The last new church that was approved was 1960. That's the Aquinas House where my wife and I were married. But there is a church, Christ Redeemer Church, that has been trying to build in Hanover for almost 20 years. And they've been trying to build on a particular property on Greensboro Road since 2016. And what they were faced with was a zoning ordinance that made it easier to build a secular assembly, such as a movie theater, and harder to have a religious assembly, such as a church. First, they need to obtain a special exception with discretionary criteria, such as Senator Prentice had mentioned. The church needs to prove that church will fit within the character of the neighborhood. What is the character of the neighborhood? What are the confines of the neighborhood? That is all completely discretionary and leads itself to completely uncertain determinations by municipal board that is rife for the potential of discrimination. In Hanover's case, they thought that the Christ Redeemer Church was too large and not like the churches that were built in the 1890s and the 1820s that had smaller congregations, and that church should fashion itself to be more like existing churches. Anytime a government decides how a church should operate and who should gather is a problem. It is a real problem, not something that we should be allowing statutorily. RSA 674-76 is not at all unique. Nearly every state has some sort of an exemption from local control zoning ordinances when it comes to religious uses. Our neighboring state of Vermont has an exemption. Our neighboring state of Massachusetts has a statutory exemption. And it is not a statutory exemption from everything. It is a statutory exemption from discretionary provisions, okay, that can be used discriminatorily. I apologize. As far as definite and objective ordinances, such as your setback ordinance or your height limitation, or something that's capable of mathematical certainty, 674-76, like the Dover Amendment down in Massachusetts, allows those sorts of definite regulations that are applicable to everyone. I also want to make clear that it's also not unique for the legislature through the RSAs to exempt or limit certain uses from the full site plan regulations or full zoning regulations. We do that for libraries and public schools, as well as things such as agritourism, cell tower co-location. There's all sorts of things in RSA 674 where there are full or partial exemptions from certain uses that are protected from discriminatory ordinances. Now, what would happen if we didn't have 674-76? Well, currently, many site plan review regulations, including the Town of Hanover site plan review regulations, allow for discrimination by saying that a church or a synagogue or a temple or a mosque needs to prove that it is, quote, harmonious and aesthetically pleasing, close quote. And also needs to prove that it is of, quote, adequate proportions. Okay, those types of discretionary provisions, I'm quoting from the Hanover Site Plan Review Regulations, are present in many, many site plan review regulations around the state. And I think particularly when we're talking about constitutionally protected uses, such as a mosque or a church or a synagogue, we need to be extra careful that we're not having local boards determine who are the winners, who are the losers, who do we want in our town, who do we not want in our town. There have been a number of cases, I've handled about 20 different cases in which particular towns decided they didn't want a particular religious group and used the planning and zoning authorities in order to keep them out. The Richmond Planning Board decided that if a particular church expanded, more of those type of people would move to the town, and the chairman of the planning board didn't want more of those type of people. We needed to litigate that. Okay, it took several years of litigation. It also ended up costing the town's insurance carrier over $1 million. That was just the settlement, not the cost of attorney's fees for multiple years of litigation. We should keep 674-76 so that towns, churches, synagogues, mosques, whatever, okay, have their rights protected. They know what they can do and what they can't do. It's a good statute, and I ask you to oppose SB 265. I'd be open to any questions, and I have a handout if I can pass it around.
Sure, just pass it out to the clerk over there. I'm gonna go first. So summing it up, basic rule I was taught a million years ago, content-based restrictions always fail, right? So they're trying to say you can't have a church and aesthetically pleasing, you're saying that's content. You're familiar with that,
So correct.
I think, okay. Okay, good, thank you, Senator, go ahead.
Thank you. So in the absence of this statute, it would be the zoning ordinance, the planning rules that would govern what this, how a church would be built. In your experience, are there certain districts in a town that allow a church or don't allow a church?
So different towns have it different. In many towns, you have churches that are allowed throughout the town. In other towns, they're allowed in residential and commercial areas, but not the industrial area. Since 674-76 was passed, they're allowed in any district. You can't say that you can't allow a church in a particular district. About 10 years ago, we had a church that wanted to build in the industrial district where event centers, and there had been a wedding venue center of 200 people who came together, were allowed, but churches were prohibited. And we had to bring a suit in order to establish that's an equal protection violation to say that you can't be in an industrial area where a secular assembly is allowed just because you're a religious assembly.
Follow. Do you think the current language that's in 674-76 gives a town license to, I mean, it gives a number of different provisions here, gives the town more ability to deny?
So the particular areas where towns can regulate are areas that are allowed by the statute, okay? And the town can regulate as long as it's regulating all uses the same. So that you don't have a different rule for a church than you have for a mosque, and you don't have a different rule for a church or a mosque than you have for a secular assembly like a movie theater. I probably should have brought up as one of the examples, the town of Bedford, they have an ordinance where they have one standard for a secular assembly, greater standard for a church, and an even greater standard for a mosque. And you can't be doing any of that. You can't be having a different standard based on the religious nature, and you also can't have a different standard based on the religious faith like the town of Bedford does. They really need to get rid of that ordinance, but that's not enforceable under 674-76, thankfully.
One more follow-up. Sure. Thank you. So in the absence of this statute, you would just rely on the zoning ordinance for that town?
Correct.
Okay, thank you.
Well, I'm sorry, if I can correct. You wouldn't just rely on the zoning ordinance for that. There's a federal statute called the Religious Land Use and Institutionalized Persons Act, which would limit whether a zoning ordinance can regulate a church. And we also have Part 1, Article 5 of the New Hampshire Constitution, which requires exemptions for religious uses constitutionally.
So you would rely on the local zoning ordinance as long as it's in line with the federal statute that is an overlay.
Federal statute, federal constitution, and New Hampshire Constitution.
Thank you.
Thank you very much. Any other questions? Seeing none, thank you very much. Kurt, I'm sorry I missed you. I should have called you earlier. Good afternoon, Representative Wolper. How you doing today?
Thank you, Mr. Chairman, members of the committee. As you've already heard, I was the prime. I want you to be officially know I'm only here representing myself. You'll hear me later for other reasons, but in this case, I was the prime sponsor of the bill that enacted that legislation. You already heard why from the person who called me and said, we need to have a bill. I said to him, are you crazy? You must be soft. That's already illegal, isn't it? And he said, well, and he gave me basically the information he's just giving you, except now he has more. So I introduced the bill. I'm very confident that my body, that I was in the House, and this body heard pretty much the same thing you've already heard today. Both those bodies and the governor, very short time ago, thought it was important enough to enact a statute. And I really think that they did their due diligence, and through the infinite wisdom of the House, as my mother used to say, they did the right thing. And I urge you to think about that. If you want to put it, study it, go ahead, study it, it'd be good. But to just repeal something like this, that for what I can see, there's an obvious need, I think would be a mistake. So I don't have any other information, so I won't take any other questions.
Thank you, Mr. Wolper. Any questions? Or are you not taking any? Okay. Sean Foster. Mr. Foster, good afternoon.
Good afternoon. My name is Sean Foster, and I'm the senior pastor of Crossing Life Church in Windham, New Hampshire. And I come today to oppose SB 265. The current law, RSA 674-76, was passed to protect churches in New Hampshire from undue discrimination and even some harassment. We've personally experienced this kind of history over the past decade. It's been a very long journey. 2013, we were denied property tax exemption and had to spend over $50,000 to contend with the town and eventually receive full exemption. These types of situations continued until more recently, the church had to spend tens of thousands of dollars to erect a tent around COVID so that we could meet outside for our services and programming. We were charged fees and asked to go through processes that no other business or organization was. We had to submit an administrative appeal to the zoning board against those officials, which we received. And they're supposed to be there to help us and guide us. Currently, we're in another legal battle with the town. This is 2025, concerning the church's use of an accessory dwelling unit in order to try to help with, the housing crisis when there's no regulation against it in the zoning ordinance. Crossing Life Church has 100 acres. We were just privileged to take advantage of RSA 674-76 to gain a full site plan approval from the town for an expanded building across the street from where our current church is. It's 100 acres split by a state road. And so we would not have been able to get approval for this without this RSA, which is we were very grateful for it. Crossing Life Church is a church that spends a lot of effort to support and strengthen our community with its programs and resources. We offer weekly events for children, young adults, youth, and elderly, regardless whether or not they even come to the church. We allow other community groups to use our property and facilities like Boy Scouts, Girl Scouts, neighboring school organizations. We offer a daycare, an academic co-op, free holiday events like Pumpkin Fest and Christmas at the Crossing, and that's attended by thousands that don't even go to the church, an agricultural mentoring program for children and youth, and a community garden in partnership with the town free of charge. We want to spend our time and energy serving as a resource in Windham and the surrounding communities of New Hampshire, not fighting against undue hardships and discrimination. I really appreciate your time today and ask you to oppose this bill and allow the current law to remain in effect to protect us and other churches across New Hampshire. I'm willing to answer any questions you might have. Really appreciate your time.
Thank you very much. Do we have any? Nope, you're in luck. Have a great day.
Thank you.
Ian Hewitt. Good afternoon, Mr. Hewitt. How you doing?
Good afternoon, Mr. Chairman. Thank you. Mr. Chairman and members of the committee, Ian Hewitt, attorney for Cornerstone, appearing in opposition to Senate Bill 265. Cornerstone is the only full-time Christian advocacy organization in New Hampshire. We represent over 100 churches around the state. And often when I come before committees like this one, or when Cornerstone is in the media for our religious liberty litigation or religious liberty advocacy, it's on kind of a conventional cultural flashpoint issue. But in spite of those issues, the main area where there is widespread discrimination against religious institutions faced by churches like the churches we represent is in zoning. The zoning is the area where there is the most widespread anti-religious, and not just anti-Christian, but anti-religious generally discrimination in the state. And it's also often the area where anti-religious discrimination is the most transparent and invidious. And you could see that in some of the examples that Attorney Tierney gave. But you can also see it in, for example, the litigation going on in Hanover right now, where Upton and Hatfield, in challenging this statute in a suit that is clearly about to be dismissed, has made probably the most explicitly anti-religious argument I've seen filed by a member of the bar, arguing very candidly that the entire concept of religious liberty should be done away with because protecting religion is somehow contrary to the separation of church and state. You heard today about the idea that prohibiting anti-religious discrimination at the local level is usurping local control. And you could say that's true in a certain sense, but as our state Supreme Court has often said, we don't live in a system of pure majority rule. We live in a constitutional republic based on the rule of law, and that involves protection for majority rights. And protection for majority rights should mean that even if a lot of people have gotten onto your local zoning board for the express purpose of keeping their community secular and keeping out any churches, mosques, or synagogues, they should not be able to do that. Before this statute was passed, 674-76, many communities were able to prevent any new religious construction whatsoever, always finding one pretext after another for decades, as you heard from Attorney Tierney. The last thing I'll note, and I'd love to take any legal questions about the law or this bill, is that you might fairly wonder, if we represent so many churches, why there isn't a giant crowd of pastors behind me. And to that, I would just plead that this has been an extraordinarily busy week for us. All our priorities have sort of come to a head simultaneously. And also, many senators have an excellent record defending religious liberty. And so we deemed this bill fairly unlikely to pass and didn't seek to engage in any kind of urgent, large-scale mobilization of our churches. But Certainly, if it were to at any point look like repeal or curtailment of this anti-discrimination protection was likely to pass, we would engage in an urgent, large-scale mobilization of our churches. And not just our churches, not just Christian churches, but when we supported the passage of 674-76, we worked with a Muslim community as well that favored the passage of this law. While I was driving to this hearing, an Orthodox rabbi called me to ask about the status of this bill. So the coalition that would be mobilized to oppose this bill, if it looked likely to pass, would be significant. I would love to take any questions about that or any legal questions.
Seeing none, thank you very much.
Thank you, Mr. Chair.
Again, I think it was Dennis. What does that look like to you? Tell,
Godspeed, my friend.
it looked, again, I missed someone on the first page who said they wanted to testify. It looks like a Dennis Tallahassee. But seeing none, does anyone else wish to testify? Who wish to speak? This better not be your name, or I'm gonna.
It's not my name. No. I originally signed up not to speak, but I just want to address one thing. Brody.
Okay.
Thank you. Thank you,
Go
Senator
ahead,
Atlas.
sir. Good afternoon.
Brody DeShays, I represent the New Hampshire Municipal Association. So I just want to flag this is primarily a land use law, and while it does impact religious properties, I want to flag the biggest difference in law, what happened when the bill went into effect on July 1st, 2022. So when it was House Bill 1026, as amended and signed into law by Governor Sununu, went into effect, it would permit site plan review that is limited to controlling the height of structures, yard sizes, lot area, setbacks, building coverage requirements, provided such requirements apply equally to non-religious and religious use and do not substantially burden religious exercise. However, what it limits is planning boards would not be able to do that other site plan review requirements that municipalities may require in certain zoning districts, such as lighting, signs, noise, on-site and off-site drainage, erosion and sediment control, layout of streets and sidewalks, utility design and installation, open space, pervious/impervious area, landscaping, and parking/access management requirements, amongst maybe several others. Those would not be, those are now not applicable to qualifying religious properties. The statute doesn't actually really define what is a qualifying religious property for this, but municipalities have implemented essentially an assumption that it would meet the definition of RSA 72:23, Roman 3, so those types of religious properties, and typically actually require those who are either building the religious structure or using a property and taking maybe a residential property or commercial property and making a religious use to be 51% or more of the time that property, that dwelling, that building is used for religious purposes. As previously mentioned, without the statute, all federal and other state laws pertaining to these types of uses and other land use codes or statutes such as state building and fire codes, local driveway regulations, septic and sewer regulations, shoreland protection requirements, wetlands, would continue to apply to qualifying properties. So as the statute's currently written, all those state and federal requirements are currently required. So our position is there is some compelling interest for those municipalities to subject any property, whether religious or not in use, to those other site plan review requirements, and it's equal to everyone. It doesn't matter who you are or how you're using the property. It's just in the interest of the local municipal government and its residents to ensure everyone is treated equally. So I just wanted to raise that it isn't, municipalities aren't discriminating against one specific type of use. They're treating all uses the same under the site plan review process. And I'll take any questions, but I just wanted to clarify that.
Thank you very much. Go ahead, Senator.
Thank you, Mr. Chair. Brody, do you oppose it or support it, the bill?
Sorry, support.
Support, okay.
I think I might have accidentally said opposed because I'm so used to saying opposed to many of the bills in this room. But yes, we support the bill as written. Yeah.
Okay, thank you.
Thank you very much. You're all set.
Thank you. Appreciate it.
Does anyone else wish to testify on 265 who we missed? Seeing none. Adjourned. We're not going to accept this today. Thanks. Thanks. Here.
Right there.
You were here. I feel your presence.
Senator Gannon, may I bring
You were always noticed, Senator.
Michael Holt with me from the Department of Health and Human Services as I introduce Senate Bill 264? Is that where
Yes,
we are?
that is where we are.
Okay, thank you so much.
Welcome back, Senator Prentice.
Well, thank you very much for having me again. For the record, Sue Prentice, State Senator, District 5, 15 communities. And I am here introducing at the request of the Department of Health and Human Services, Senate Bill 264. This is relative to the therapeutic cannabis program. This is going to do three things actually, that align with two different pieces of legislation that have passed within the last, I think it's year. In the last year. One is House Bill 1222, which dealt with the physician's assistants, their collaborative agreements, not scope of practice, but their collaborative agreements, and SB 357, which has to do with an expansion on who can certify providers for therapeutic cannabis. So these have been passed, but with legislation that gets passed, there are times when we have to make corrections to current, other related statutes. So Michael's going to go into greater detail, but number one, as it relates to the physician's assistants, this will allow the physician's assistants who certify their patients for therapeutic cannabis, for the use of cannabis therapeutically, shall have a collaborative agreement only if they're required by their scope of practice. Okay, so this bill fixes that misalignment in that language that with the passage of both 357 and 122. The second is, and this is more specific to 357, where it allows for certification by other providers, and some of the other providers, again, with therapeutic cannabis, would be podiatrists, dentists, naturopathic doctors, optometrists. They are some of the providers that are now allowed to certify patients, but when they're in, now that they're allowed to, there has to be a mechanism in place in terms of oversight if there is any, as it relates to provider conduct. So that we need to align in item number 2. And then in last, it establishes that the prohibited relationships between providers and New Hampshire Alternative Treatment Centers, or ATCs, also apply to out-of-state cannabis dispensaries and entities. So this isn't related directly to the two bills that were passed last year, but this needs to be done. So at the department's request, I added this in. So we are aligning statutes that have been passed with statutes that are in place. So these certifications can take place, and there can be certifications can take place. There can be proper oversight, especially with the addition of these new providers, and we deal with the in-state, out-of-state issues. That is my introductory testimony, and again, I have Michael Holt with me for questions that I cannot answer, but I will
So
always do my best.
Your third point, I think, in part 3 was to prevent unethical behavior. Is that correct? You said you had 3? That would be.
There are 3. No, the
Okay.
third one, the second one has to do with provider conduct.
I'm with you.
Okay,
Yeah,
the third,
I'm good.
Oh, you're good?
Yep.
oh,
We'll just let it go. I was just giving you a hard time.
well, okay.
Okay.
Thank you, Senator Gannon.
Thank you. Yes, go ahead, Mr. Holt.
Thank you very much. For the record, my name is Michael Holt. I'm the administrator of the Therapeutic Cannabis Program within the Department of Health and Human Services. Thank you, Senator Gannon, members of the committee for hearing this bill, and Senator Prentice for sponsoring it. This is largely remedial legislation from last session. I'm happy to answer any questions, but Senator Prentice did an excellent job of framing these issues. In the first instance, this bill would clarify that physician assistants who certify their patients for cannabis shall have a collaboration agreement only if that collaboration agreement is required. So, and this aligns House Bill 1222 and Senate Bill 357 from last session, which created a misalignment in language. So this simply clarifies that language in RSA 126X. Secondly, the expansion last year from Senate Bill 357, which expanded provider types. There was a related piece of statutory language under RSA 126X, which is the therapeutic cannabis law, that gives the department the authority, the responsibility to refer those providers to their appropriate regulatory board and allows those regulatory boards to prohibit their participation in the therapeutic cannabis program if warranted. So these new provider types were not included in last year's bill, and so that's what this attempts to do, is that includes all of the appropriate regulatory entities that are now allowed to certify. Lastly, and this does not, as Senator Printer said, this does not have to do with legislation from last year, but it does have to do with certifying providers in the state. It establishes that the currently prohibited relationships between providers and New Hampshire Alternative Treatment Centers, or ATCs, also apply with regard to out-of-state cannabis dispensaries. This is essentially a conflict of interest provision in 126X, which says that a certifying provider shall not have X relationship with an ATC. This is a loophole that this bill is trying to fix, and this would prohibit the same relationship between those providers and the ATCs and apply that to out-of-state cannabis dispensaries. And that's the summary. I'm happy to answer any questions about any of these aspects of the bill.
Yes, go ahead, Senator.
Thank you, Mr. Chairman. Thank you for taking my question. You mentioned that the first change would be that only if the collaboration agreement is required. What are circumstances where the collaboration agreement wouldn't be required?
So House Bill 1222 was a large piece of legislation that changed the scope of practice. I would defer that to a medical professional behind me, Representative Knirk, to explain that. But the point of House Bill 1222 was to eliminate the collaboration agreement requirement in many cases.
Anybody else?
Well,
Do you want me to take that?
Whoever wants to answer.
Thank you. So when we passed this last year with the physician's assistants, there are a group of physician's assistants who are under a waiver provision for a 2-year period. We finished the study committee and made further recommendations, so it could apply to them. That's all, Senator Abbas. It is a temporary provision. We're going for eliminating collaborative agreements unless they meet a certain hour requirement. So it's just aligning it with that.
And if I can ask another question, and I'll direct this at both of you if you want to respond. How many providers have been, I guess, reported for violating any of these provisions? And since the therapeutic cannabis been...
None in recent memory.
So by adding this prohibition, which I certainly understand why, if you can't have an interest in state, why change if you have an interest out of state? But I guess my question is that something that's happening now? Are there people with interest out of state that have an interest in a therapeutic or a retail cannabis facility?
Are you referring to item 3?
Yes.
Yes, we're finding that New Hampshire certifying providers are advertising inappropriately on, well, it's not inappropriate, that's the thing. There's no prohibition against it, but are advertising on dispensary websites out of state. They would not be permitted to do that with a New Hampshire ATC, but they are currently doing that out of state. So we don't have a mechanism to even send them a letter to say stop. So the goal of this is to provide us with the authority to match the prohibitions within state with those relationships out of state.
So if I'm understanding this correctly, let's just say these out-of-state facilities, they're in compliance with their state law, but they're now, from what I gather, wouldn't be in compliance with New Hampshire law. Does that?
We're not trying to regulate the out-of-state dispensaries. We're trying to regulate the in-state providers.
Yes, but I guess if they own something out of state, that means the in-state providers can no longer make these certifications.
In certain cases, that would be true, yes.
And are there people in the state of New Hampshire right now that would be impacted by this?
There are providers in state who are advertising on out-of-state dispensary websites that would, under this law, would be prohibited from that advertising. It would not prohibit them from certifying if they stopped that behavior, no.
And if I just let's follow up, what's the interest, I guess, with prohibiting them from advertising out of state? I mean, I know we can regulate advertising in state, but is there an interest to stop them from doing it out of state?
Well, we're seeing this mostly in terms of Maine medical marijuana dispensaries. And as you know, Maine medical marijuana dispensaries are not regulated by the state. And so when we have New Hampshire providers certifying New Hampshire patients for the New Hampshire program, and yet they have a financial relationship potentially with a Maine dispensary, that Maine dispensary is not regulated by the state. And we believe that the Maine medical product, not in all cases, but in many cases, is unsafe due to it not meeting, not having the same requirements for testing, pesticide control, labeling, et cetera. So we are endeavoring to prohibit the advertising relationship so that these providers are not telling their patients, go to a Maine dispensary, because the Maine dispensaries may very well be selling products that have pesticides or other contaminants in them.
Thank you.
Okay, seeing no other questions, thank you both. Representative Nurk. Good afternoon, sir. How you doing?
Thank you. And for the record, yes, my name is Jerry Knurk, and I am a retired House of Representatives and also retired surgeon. I serve as the chair of the Therapeutic Cannabis Medical Oversight Board, and that is, of course, statutorily charged with medical oversight of the therapeutic cannabis program in New Hampshire, composed of 10 medical providers from various specialties, medical director, DHHS, clinical representative from the ATC, and a patient representative. We voted unanimously to support this bill, which is the department requested, as we discussed. Now, basically, in answer to the question you asked earlier about which one had ethical standards, well, they both 2 and 3 deal with ethics in a different way, and I'll cover that. But the bottom line is that our program has very high quality standards for testing for cannabinoid content and for impurities. Our program also has very high, we think, ethical standards. We view that what we're doing with cannabis is using it therapeutically as part of medical care. It's not just a way to get cannabis. So we have such tight restrictions on it. So yes, in section 1, I'm going to go a little bit into, if you excuse me, the weeds on this, but in any case, regarding physician assistants, it's important to recognize that when PAs first became a profession, they were closely supervised by physicians. I supervised some in my practice. There's been a trend gradually over 20 years or so of transitioning from these supervision models to collaboration models. And when PAs were added to the list of patients who could certify for therapeutic cannabis in New Hampshire back in 2019, we were still using the phrase supervising physician. So that was in statute. Then the model, though, was changed to a collaborating physician model in 2022. But when SB 357 came forward in 2024, it was pointed out that this language that was being used in that bill wasn't consistent because it still referred to supervising physician. So we actually corrected that to collaborating physician. So that's what got into statute via SB 357, the comment about a collaboration agreement. Well, the problem is HB 1222 changed that scope of practice. The issue is it has to do with basically experience of the PA. If you've got over 8,000 hours, you can apply for a waiver from the collaboration agreement. It's not automatic. You have to apply to a waiver. And actually, the Board of Medicine is still working on what the criteria are to grant a waiver in this setting. Less than 8,000 hours, you still have to have a collaboration agreement. But the bottom line is the statutory language regarding PAs aligned by 357 did not align with the scope of practice changes because it just said you had to have a collaboration agreement. And that, again, as we point out, by HB 1222, passed the same year, no longer exists for everybody. But it will be a small group. And in fact, what they're particularly debating in the Board of Medicine is you have to practice in the field in which you're actually going to be practicing. I mean, all those kind of things the Board of Medicine is now digging into to try to figure out how they will allow these waivers to occur. And my paragraph at the bottom of the first page goes into the details and the time course of that, but I just gave you an overview. So yeah, Section 2, there was another oversight. Again, DHHS currently can point out provider misconduct to the Board of Registration. And the authority already exists in 126X4. And this would be sent to the appropriate regulatory board. SB 357, which allowed an expansion of the providers, which we've already talked about, it actually expanded them to anybody who can prescribed to humans and has a valid DEA license. So again, it included now podiatrists, dentists, naturopathic doctors, and oversights. But there was a bit of an oversight on the part of us passing this bill that we did not extend that departmental authority to refer concerning conduct. So this is the ethical part. If you have a provider who's now a podiatrist who now can do it, and they're doing something really wrong in terms of how they're certifying for cannabis, right now there's no authority for the department to be able to make a referral to their board. So, for example, the Board of Medicine, that's where if you're a medical doc, you'd be referred to them if you were doing something that was inappropriate. So SB 264 would allow the department to refer concerns about provider conduct to the appropriate regulatory entity for the additional provider types. And it would also, again, allow those regulatory entities to direct the department to say, hey, you can't let this person certify for therapeutic cannabis because they are really not acting properly. So that's one piece of ethics. The other piece of ethics is pretty straightforward. Again, it has nothing to do with those two bills, but a loophole that's been in current law as we gradually expanded and allowing some with our providers. Bottom line is there should not be a financial conflict of interest when certifying patients for the therapeutic use of cannabis, because then you're.
I'm going to interrupt you.
Yes, sir.
Senator Abbas has to leave. Can you ask you a question right now first?
Yes, sir.
Thank you, Mr. Chairman, and thank you for letting the chairman interrupt you.
Yes, that's fine.
And
we're here to help.
Just a question on page, well, it's only one page, but on line 29, it says cannabis dispensaries, but if you look above on line 21 and 26, it only references the ATCs. I'm not aware of a definition of cannabis dispensaries in New Hampshire. So is that meant to apply to both a retail facility and a ATC, or because I understood what I understood this to mean is because this is a therapeutic cannabis section chapter, it's always referencing therapeutic cannabis. But Mr. Holt testified that there was a loophole, and this is to fix it. But it seems to me that they would fix the ATC loophole, but is there an issue of a
Well, the issue is the first part, lines 20 through 27, are already in statute.
Yes.
So those are already there, and they have to do with New Hampshire and ATCs. What we're trying to do is expand it to behavior that is occurring outside of the state. And other states don't call them ATCs. They usually will call them dispensaries. So dispensary is being used in a generic sense here of, it's like saying you can't do it in Walgreens. If you're going to, over here, you're going to say you can't do it in a pharmacy. So because the other state, for example, Maine doesn't call it an ATC. It's a cannabis dispensary. And this, since lines 28 and 29 extend those prohibitions to the cannabis dispensaries or entities, i.e. a company in other states. So we can't use ATC for those other states because they're not ATCs.
I understand when in Rome, you got to call it by what it's called. All I'm asking is, does this expand the existing law to apply to any finding economic interest in, let's say, just a retail store?
Yes, in other words, if they have they're already prohibited to do that within our state, but we didn't want them to be able to do it in other states as well because it's a compromise of your ethics. It's a financial conflict of interest. So, for example, if they are in Maine, they work in a dispensary, they're advertising on their website. They may also certify New Hampshire patients. And we view that as a conflict of interest because they are getting financial reward by making that certification. In other words, it says, hey, if it's bad behavior to do this in our state, it's bad behavior if you do it over in that state.
No, I understand
Yeah.
that. All I'm asking is, would this expand to a retail store? Because we don't have a definition at the state level of a cannabis dispensary. It's not defined in the ATC chapter because it's simply for therapeutic use. I think the goal is to, I think the intent is for it to apply to a retail store. I'm just asking, as it's written, I'm not clear that it does, but we could make it clearer that it does apply to retail as well. And that's my question.
Well, I mean, if you think the language needs to be tidied up, we could, but I'm just not sure it does because it's saying cannabis dispensaries and other cannabis entities in other states. So a retail store in Maine is going to fit that criteria already. It would be a cannabis entity in another state. So I think it's probably covered, and it was kept, again, somewhat broad because of the fact we don't use specific names. If we start saying it can't be thus and such a name in this state and thus and such a name in that state, it gets to be rather cumbersome. So if you put it as cannabis dispensaries or entities, that ought to cover it, in my thought.
Thanks.
Thank you.
Yeah, thank you.
Quick question for just to help
Yes.
me. I don't know why I'm stuck. How do we have jurisdiction to tell anyone in another state what to do?
We don't. We're not saying you can't do it in that state. We're saying if you do it in that state,
Yeah.
that we don't think your ethics are somewhat compromised. We don't want you certifying in our state.
Okay. Affected by what you do.
Yeah.
Okay, thank you. Go
So
on.
just to kind of finish that a little bit, I think we covered section 2 completely, and I think we kind of beat to death section 3 a little bit there. I mean, the bottom line is that we do not, when the Therapeutic Cannabis Medical Oversight Board feels strongly that this should be treated as as something that is being offered for patients, not something you're doing because you're trying to make a buck. And so we don't want financial conflicts of interest. So we feel it's perfectly appropriate to say that, even out of state, you ought not to be doing this. Yeah. So anyway, Therapeutic Cannabis Medical Oversight Board really requests your support of this because we think it is the proper way to keep our program with high ethical standards and also, again, tidies up some language.
Thank you. Seeing no questions, you have a great afternoon.
Okay, thank you.
When to go? Representative Wendy, is that you in the back? How you doing? How do you say your last name? I didn't want to say it wrong. Thomas, it does. Oh, I see it now. Looks like a big P with the swirl. Anyways, okay. Good afternoon.
Good afternoon. Thank you, Mr. Chair and members of the committee. For the record, my name is Representative Wendy Thomas, and I represent the town of Merrimack. I'll be very, very short. I'm just letting you know that the 3 representatives, Heath Howard, Suzanne Vale, and myself, who do the heavy lifting for the therapeutic program in the House, are all on board with this bill as written. That's it.
Short and sweet. Thank you. No questions. Anyone else wish to testify who didn't have a chance? Seeing none, I'll end the hearing. We're gonna wait. Daryl wanted to talk about this. We'll wait till next week. I was going to executive them. One page, I'm happy. One page. All you can do. It's all so far. Senator Elschler, everyone has signed in and the room's getting quiet, so anytime you're ready. I'm opening the public hearing to 260. Senator Elschler is introducing the bill. Thank you, Senator.
Thank you, Mr. Chair. Good afternoon, committee. For the record, my name is Senator Deborah Altschuler, representing District 24, the towns of Stratham, Exeter, Greenland, Rye, Hampton, Northampton, and Hampton Falls. I'm here today to introduce Senate Bill 260. Senate Bill 260 will protect a fundamental aspect of healthcare in our state. This bill affirms that prior to 24 weeks gestation, the right to terminate a pregnancy shall not be infringed upon in New Hampshire. The bill before us recognizes three important facts. First, abortion is a critical component of comprehensive reproductive health care, and access to abortion allows people to make deeply personal decisions about their families and lives. Second, in 1997, our state's bipartisan legislature repealed an unenforced 1955 abortion ban to ensure access to essential abortion care in New Hampshire. And third, President Trump has stated that the regulation of abortion should be left to the states. This legislation upholds New Hampshire's longstanding tradition of protecting individual liberty and personal privacy. It codifies into law what many in our state already believe, that decisions about pregnancy should remain between a person, their doctor, and their family. When we talk about abortion access, we are talking about health care. We are talking about people facing complex, often difficult circumstances who need to be able to make decisions with their healthcare providers without government interference. This bill's 24-week framework aligns with medical standards while providing clarity and certainty for patients and providers alike. Consider the real-life implications of restricting this care. A woman with a wanted pregnancy discovers a severe fetal anomaly that is incompatible with life. A person with a high-risk pregnancy faces serious health complications. A young victim of sexual assault needs compassionate care. In all of these cases and more, people deserve access to the full range of healthcare options. Some may ask why this legislation is necessary in New Hampshire, and the answer is simple. Without explicit protections, access to critical healthcare remains vulnerable. We have seen numerous states enact restrictions that have created dangerous situations for patients and providers. We've heard heartbreaking stories of people forced to travel hundreds of miles across state lines while in medical distress because they could not access timely care in their home state. New Hampshire has always valued personal freedom and limited government intervention in private life. This bill honors that tradition. It doesn't mandate anything. It protects a person's right to make their own decisions according to their own circumstances, beliefs, and medical needs. In 1997, our legislature acted in a bipartisan manner to remove outdated restrictions on reproductive health care. Today, we have the opportunity to build on that legacy by providing clear, affirmative protection for abortion access in our state. It's worth noting that this bill respects diverse viewpoints. It doesn't require anyone to have an abortion or change their personal beliefs about abortion. It simply ensures that each person can make their own decision according to their own values and circumstances. The debate around abortion has long been divisive in our country, but surely we can agree that such deeply personal healthcare decisions should not be made by politicians. They should be made by individuals in consultation with their healthcare providers, guided by the best medical evidence. President Trump himself has stated emphatically that these matters should be decided at the state level. This bill represents New Hampshire taking responsibility for establishing clear policy that reflects our state's values of liberty and personal autonomy. For healthcare providers, this bill provides much-needed clarity and protection to deliver evidence-based care without fear of prosecution. For patients, it ensures they can access the care they need without unnecessary barriers or delays that can increase medical risks. To be clear, Senate Bill 260 does not mean endorsing abortion. It means endorsing freedom. The freedom of each person to make their own healthcare decisions according to their own conscience and circumstances. As we consider this legislation, I ask you to reflect on the real people whose lives will be affected by our decision today. Think about your constituents who may face pregnancy complications, health risks, or other circumstances that lead them to consider abortion care. They deserve compassion, not judgment. They deserve access, not barriers. They deserve to have firm ground under them on which to make personal medical healthcare decisions. Granite Staters want and deserve to be secure in knowing that their government trusts them. By supporting Senate Bill 260, we will affirm that in New Hampshire, we trust people to make their own personal healthcare decisions. We will ensure that healthcare providers can offer evidence-based care without political interference, and we will uphold our state's proud tradition of protecting individual. I respectfully ask the committee to recommend Senate Bill 260 ought to pass. Thank you.
Thank you, Senator. I just have a couple of questions, and we'll see if the other side does. So today, my constituents are already protected through 24 weeks, right? If they find out a fetal fatal anomaly in the 22nd, 23rd week, they can get an abortion right now, right? They're protected under state law. So my question is there going to be any real tangible difference between what we have right now, which is 24 weeks, you're entitled to get an abortion for any reason in New Hampshire? Is there a difference between an outcome between your bill and what we now have?
Thank you for the question, Senator Gannon. Actually, I appreciate you opening this avenue of conversation. The tangible difference that is made by Senate Bill 260 is that currently there is no affirmative right to abortion health care. And with the shifting sands underneath the feet of pregnant people in our state, people who want to become pregnant, people who don't want to become pregnant and become pregnant, knowing firmly that their state has affirmed abortion access up to 24 weeks allows both patients and providers to move forward with certainty and clarity.
If I can follow up with you?
Thank you. Yes.
Sure. So under the same thoughts here, we have, this isn't a constitutional amendment, so
No.
it could be changed by the next legislature, so you're still really standing on sand unless you got a constitutional amendment, which would be very hard to change. So by doing this, another year and a half from now, we could be back here doing the same thing. There's nothing in cement. You're not cementing a right to anyone, an affirmative right. It's just everything's temporary that we do, unless maybe a little more cemented if we have a constitutional amendment. So I don't see that you're really giving anyone any more than we already have. I understand you're saying it's an affirmative as opposed to, but I don't see that as a tangible difference.
Sure. So this legislature is charged with creating laws to apply to our state. So everything we do can be changed in 2 years. Our entire legislature can be upended every 2 years according to the electorate. And we know in New Hampshire that abortion healthcare rights have been shifting. We have endured an overturn of Roe at the federal level. We have endured a very draconian abortion ban that was inserted into a state budget, and then we had to claw back certain portions of that, like a mandatory vaginal ultrasound. We have shifting sands. It's time for New Hampshire to definitively state your rights to abortion healthcare access up to 24 weeks is firm.
Thank you, Senator. Do you have a question? Go ahead.
Thank you, Mr. Chair, and thank you for taking my question. So when I look at every bill, I always look at existing law to see where this would fit into existing law. And this is a brand new chapter. There is no written statutory law at all right now, correct?
Correct.
Thank you.
Seeing no other questions, thank you, Senator.
Thank you very much.
Mike Tierney again. Geez, you're first up, last up. Good afternoon, sir.
Good afternoon, Senators. Michael Tierney, I'm here.
Mike, I'm sorry, we're gonna have it limited to 2.5 minutes,
Absolutely.
just so everyone knows it's starting off. Thank you.
I'm here to oppose SB 260. The purpose of government is to protect life, the life of the mother, the life of the baby, the life of the father, life of all peoples. That should be the ultimate goal of government, is to protect life. And I'm confused by what this bill will actually do. Does it eviscerate all infringements on getting an abortion? Is it a backdoor repeal? Is it a trumping of the parental notification law? Does it also trump any laws that require a clean and well-regulated surgical center as an infringement on getting an abortion? Does it trump laws that limit chemical abortions to no later than 10 weeks, even though the FDA has found that thousands of women have had severe medical complications, even dozens of deaths, when taking these pills so late? The language "shall not be infringed" does not appear in any other comparable statute. The only place where I could find "shall not be infringed" is in the federal Second Amendment, that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. If the intent of this bill is to follow the Second Amendment case law, the bill should make that clear. Under current U.S. Supreme Court precedents, Second Amendment rights can only be infringed if they're the type of infringements understood as permissible under the Founders' Generation. Where this bill uses the same "shall not be infringed" language, courts may apply the same Founders' Generation test to this bill as well. Or maybe they will not. This is not a clear or explicit bill in what it's doing. The only thing that's clear and explicit is that this bill, if passed, will encourage litigation and do absolutely nothing to protect the life and safety of mothers or babies or anyone else. And so I would encourage all the senators to vote no on this bill. And I'd be open for any questions if anyone had any.
Thank you. Seeing none? Okay, thank you very much. Yes. Oh, that's okay, thank you. Kurt? I'm gonna still call you representative because you get the title for life, I believe. Good afternoon.
Good
Representative
afternoon, Mr. Chairman, members of the committee. And again, my name is Kurt Welper. I'm from Stratford. I am also the chairman of the New Hampshire Right to Life, whom I represent here today, and all those that are pro-life in our state. The sponsor of this bill just testified that this is not for the bill is not intended for the state to sanction abortion, to approve of abortion, but that's exactly what it is. When we say that the right to abortion cannot be infringed, what are we saying except abortion is a really good thing and it can't be infringed? That's awful. Abortion itself is a cancer on our society. It corrupts everything it touches. It corrupts the family by pitting the mother against the child at a time. They should never have competing interests. It corrupts medicine by making those who go into the healing arts killers. Killers. It corrupts our law. Just look at what we have. On the one hand, if a third party kills a baby of only 20 weeks gestation, that's a homicide. But if a mother wants to do it, she doesn't need a reason, and it's going to be sanctioned by the state. How can you do that? How can we do it? We cannot do it. Morally, everybody knows that killing other people is wrong. But this bill says whoever gets to choose an abortion, which is pretty much mothers, can kill another person anytime they want. The Supreme Court recognized this in Roe versus Wade, for Pete's sake. The bill, the decision itself has been overturned. But the portion that said, if we knew the object of the abortion was a human being, that human being would already be protected by the 14th Amendment of the United States. We know. I urge you to support this bill.
Thank you, Representative. Any questions? Seeing none, have a great day. Sean Foster.
Good afternoon again. I'm Sean Foster from Crossing Life Church, and Mr. Chair and honorable members, I would ask that you consider not only the safety and welfare of the mother, but also that of the child. The child has a right to be born equally free and independent. If we're in this room, we've all had this opportunity, and the right to defend life and liberty. Every person, including mother, father, and child, deserves the right to life and not have that life infringed on. Jesus willingly gave his own life on the cross for all men, all women, and all children. And he's given the opportunity to all of us to be saved and receive eternal life. This was all out of his great love. I respectfully ask that you oppose SB 260 today. Thank you.
Thank you very much. Seeing no questions? Thank you. I'm assuming there's another sheet, guys. Thanks. Thank you. Lynn Stanley. Oh, no, you don't want to speak. I'm sorry, Lynn. Claire Tylori. Good afternoon, ma'am.
Thank you, Mr. Chairman, members of the Senate Judiciary Committee. For the record, my name is Claire Tayluni. I'm here on behalf of Reproductive Equity Now to speak in support of SB 260. Reproductive Equity Now works across New England to make equitable access to the full spectrum of reproductive health care a reality for all people. As New Hampshire is the only state in New England without affirmative legal protections for abortion, either in its statute or in its constitution, Granite Staters are not impervious to or immune to the threats to abortion care that we're seeing across the country and those that we expect to see coming from the national level. These threats and the patchwork of laws governing access to abortion care nationwide result in chaos and confusion and harm for real people in real communities who need access to basic and essential healthcare that gives them the freedom to make their own decisions and to fully control their own bodies, lives, and futures. This is why we are urging you to act today favorably on SB 260, legislation that will clearly and simply communicate to residents of New Hampshire that abortion is healthcare, that abortion is a critical component of comprehensive reproductive health care, and that individuals here in New Hampshire have the right to decide to seek abortion prior to 24 weeks without government interference. Across the country, as I've noted, chaos and confusion abounds with regard to understanding the legality and accessibility of abortion care. Polling shows that over half of all American women are unsure about the legality of medication abortion in their state. And SB 260 offers an opportunity to combat this misinformation and confusion and to help Granite Staters cut through the noise with a very simple message. Abortion is a critical component of reproductive health care, and our state government will not infringe upon this right to care. Granite Staters overwhelmingly support reproductive freedom and believe that there should be a right to abortion in every state across the country, including New Hampshire. After Dobbs has handed the fight for abortion access back to the states, SB 260 is New Hampshire's opportunity this session to take positive action, affirming reproductive freedom for Granite Staters and affirming the reproductive freedom that Granite Staters are looking for. Advancing this bill very closely aligns with New Hampshire's longstanding history and legacy of affirming personal freedoms and liberties, and we urge you to support it. Thank you.
Quick question. So you've been around here and you do studies and you must do polling. In New Hampshire, I can't believe that any woman isn't aware that it's 24 weeks after the last year of TV ads and stuff. Is there data that there are women in New Hampshire who are confused at 24 weeks?
That polling I was referencing was about all of American women. I'd be happy to follow up on the polling that I was referencing about the majority of Granite Staters who support abortion, the legality of abortion. I don't have the details that you're asking
That'd be
for,
great.
but I'd be happy to follow
Okay,
up.
thank you. Do you guys have questions? Seeing none, thank you very much.
Thank you.
For coming today. Liz Canada, I saw you there somewhere. Come on up. How you doing today, Miss Canada?
I'm doing okay. How are you doing?
Fine.
It's been a while since I've been here. It's good to see you.
I'm sure we'll see you a lot this year.
Who knows? Who knows what'll happen? Okay. Thank you so much. So, thank you, honorable members of the Senate Judiciary Committee. For the record, my name is Liz Canada. I'm the Advocacy Director of Planned Parenthood New Hampshire Action Fund and Planned Parenthood of Northern New England. We're in strong support of Senate Bill 260. When the U.S. Supreme Court overturned Roe v. Wade in June of 2022, they took away the federal right to abortion, which has led to, as of today, 19 states which have banned abortion outright or severely restricted it. That number has changed over the last few years because of court cases and because there are some states that have passed constitutional amendments. I heard, Mr. Chairman, you mentioned, the potential constitutional amendment question. So those numbers change. But as we've heard from a few different folks here, New Hampshire is the only state in New England that doesn't have explicit rights in state law or the state constitution for abortion access. In the fall, a survey showed that 64% of Granite Staters want their state lawmakers to take positive, proactive action on abortion rights. And that's what Senate Bill 260 is. It's putting in clear language that the state will not infringe on the right to abortion prior to 24 weeks. So it doesn't change the current abortion law. It just puts that very clearly into our RSAs. Now, leading up to the 2024 election, there were quite a few lawmakers, folks campaigning and saying that they did not want to further restrict abortion, and they were making that a campaign promise. So this is putting that promise into action. This is putting a vote in front of you to support protecting the right to abortion prior to 24 weeks. And so we strongly encourage you to pass Senate Bill 260. Happy to answer any questions.
Oh, I'm sorry. Senator Atlas, go ahead.
Hello.
And I'm back.
Here you are.
Back with many questions. And thank you
Great.
for taking my questions.
Of course.
If I understood your testimony correctly, this makes no changes to the substantive law?
Thank you for the question. So this does not change any of the restrictions on the books. That's correct. It does put in the protections directly into state law. Right now, we know that there's the RSA that says there's nothing in the Fetal Life Protection Act giving the right to abortion. So this is being really clear about prior to 24 weeks that the state will not infringe on that right.
But if this were to become law, what actual changes to the law and how it's applied would there be?
Thank you for the question. So as I said, in the survey from the fall, constituents want their lawmakers to take positive action. In the other chamber, I won't mention them, but there have been further bills to restrict abortion and to, whether it's gestational bans or other types of restrictions. And those have been defeated so far, which is great. Voting against bad things is one part of the equation. Constituents want lawmakers to vote for positive changes as well. So this would change it in a positive way to say, yes, there is not going to be any infringement prior to 24 weeks.
Oh,
So I understand that you're referencing a survey that 64% want a positive change.
Yes.
But if it doesn't change the substantive law in any meaningful way, I'm not or anyway, for that, I'm not sure what the change in the law is. And so if I go to that 64% and say, hey, this is what the change is, what is the difference between today
Sure.
and this becoming law?
Thank you for that question. So the change is that in New Hampshire, we're the only state that doesn't have anything in state law or our state constitution that says there is a right to abortion. And so it would change it in that way, a very clear change, and put us in line with the rest of New England.
Thank you.
I'll just ask a quick question following his thoughts. Your 64% of constituents who want change, do you know how many of them realize that we have 24 weeks in place? Because most of the emails I got said, we want to protect a woman's right to 24 weeks. And it seemed like they were asking for the 24 weeks, not for the positive part, because it seems like almost every email, they weren't aware of the 24 weeks. Or so out of that 64%, do you have a breakdown of how many are aware that we have a right now for 24 weeks?
Thank you for that question. And I'm glad that people are emailing you. That makes me very happy to hear that they're contacting their lawmakers.
I read them all.
I'm glad to see that. So I don't know how each of those 64% people think of the current law. I, as a former educator and as somebody who does this work to explain how our laws work, I would love for everyone to know what exactly the law is. That's part of my job, right? But what I do know that folks understand is that it's frightening what's happening at a federal level. It's scary to see other states ban abortion, to hear about the stories of women who have died in states who have been denied care. And they want to know that in New Hampshire, one, that that's not going to change, that we are not going to further restrict abortion here, and that you are showing a commitment that you're not going to do that. And that is by voting in support of 260, that is that clear commitment. The 24 state senators, only you can vote on these types of things. You can demonstrate that by voting this bill to pass. And so that's what they're looking for.
Do you guys have any questions over there? Yes, go ahead, Senator.
Thank you, Mr. Chair. Thank you for taking my question.
Of course.
I once again am looking at the existing law and what's proposed before us here. And if I was doing a search of the New Hampshire statutes right now, and I was looking for access to abortion care, the title of this bill right here, and I put any of those words into the statute, none of that would come up with it. But there is a pretty convoluted couple of paragraphs here about the prohibitions of abortion care. Would you agree that this would make the question that people in New Hampshire are asking about the certainty over what was legal in New Hampshire, this would clarify it?
Yes, I absolutely agree with that.
Thank you.
I think anytime we can offer that clarity in state law, I think it's better for all constituents, no matter what their background and beliefs are. Thank you.
Seeing no other questions, thank you, Ms. Kanda.
Thank you.
Courtney Reed. Good afternoon, Ms. Reed.
Hi, good afternoon, members of the committee. For the record, my name is Courtney Reed. I serve as policy advocate with the ACLU of New Hampshire, and I will be speaking in favor of SB 260. So, as you've heard, SB 260 is a simple bill that affirms the right to abortion prior to 24 weeks gestation without state interference. It also acknowledges abortion being a critical component of reproductive health care. Also, just to reiterate, the previous speakers, passing this bill now is more important than ever after the fall of Roe in June of 2022, placing the fight for abortion access back in the hands of state governments. And so far, the consequences of these restrictions on reproductive care that we've been seeing nationwide are simply things that we cannot afford to face here in New Hampshire. So I'm sure you've seen the news and heard the data on some of the horrific health impacts of abortion bans in states across the country. So the year after Roe was overturned, we saw that 25 million people lost access to abortion care in their home state. So that was 2022 data. I'm sure that the numbers have certainly gone up since then. We've also seen over 100 pregnant women in medical distress being turned away from emergency rooms after the fall of Roe. And in Georgia, we saw 28-year-old Amber Thurman die after being denied legal abortion care, confirmed by the state's Maternal Mortality Review Committee. We also know of the economic consequences of denying access to reproductive care, as well as the consequences in interpersonal spheres. Individuals are more likely to stay with abusive partners if they are denied access to reproductive care. And so the bottom line really is that the legislature is not more qualified than medical experts to make blanket decisions about reproductive care. And I think just a few of these things that I've spoken to is a testament to that. And we also know from polls that Granite Staters overwhelmingly support access to abortion rights. So SB 260 is a great way to honor the values and messages of constituents and recognizing that we need to trust doctors and patients, which includes being able to receive the care that we need without worrying about threats to our health, freedom, or well-being. And with that, right on time, I'm happy to take questions.
Thank you, Ms. Reed. Same quick question we've been asking. In New Hampshire, whether this bill passes or doesn't pass, there'll be no substantive change to reproductive care for women. Is that correct?
Thank you for your question, Senator Gannon. To circle back to your previous comment about constituents emailing you, I think one real material consequence of this legislation is that you would then have the ability to point to something in statute to say, actually, yeah, this right is affirmatively protected in state law, whereas I'm not familiar with data on what the majority of the population believes their rights are at the time. I'm happy to follow up with you on that, but I think that being able to find a chapter that affirmatively points to that right is really important at this time, as we're seeing waves and waves of further restrictions on care. And I would also like to follow up on the legal ramifications of having this in statute when it comes to challenges on infringements of rights to reproductive care.
Yeah, just a quick follow-up. But at this time, I can point to current law and it says you have a right to abortion up to 24 weeks. So I can point to that as it is now. Can I not?
Thank you for the follow-up, Senator. I would disagree with that. I know that there is a construction clause that was part of the Fetal Life Protection Act that actually says nothing will construe the right to an abortion. So there is not an affirmative right at this time.
Okay, thank you. Senator Abbas?
Thank you, Mr. Chairman. And thank you for taking my question. You mentioned some other states and some of the laws that they passed and some of the ramifications that you believe was more a result of those laws. I think you mentioned Georgia, I want to say Texas. Well, if this were to pass, and let's just say whether it's the Texas law, Georgia law, we look into the specifics of what those laws are, I think it's my understanding those are more restrictive than anything we have here in New Hampshire. If a future legislator were to ever entertain doing that, wouldn't they just repeal this law in the process of doing it?
Thank you for your question, Senator. Yeah, I mean, I think that, that's the way that things work. We see statutes created and statutes repealed, and I would hope that the body would vote on this as a first step to have broader protections in place in the Granite State.
Go ahead, finish.
But how does this create broader protections? I guess my point is, I understand the language people may want to see it in law, but if it doesn't change the law in any way, then at least I don't understand how it does. And I'm just hearing that people want it in the law, but it's not making it change to the law, at least in the sense that it's actually changing how it's applied here in New Hampshire. We can't control what they do out of state, and the other states do. That's a state-by-state basis here. So I'm trying to figure out, even if we pass this, it's not going to necessarily have any impact on a future legislator, whether they want to make it any more or less restrictive.
I appreciate the follow-up. I would contest that this does have a legal impact on the state of the law and that courts could use the statute should this right be infringed upon in the future. I understand that the legislature could repeal it, but I think while this law is in place, it offers an added protection that is just not anywhere in the RSAs right now.
Thank you. Senator Altshuler.
Thank you, Mr. Chair. Thank you, Ms. Reed, for taking my question. Are you aware that in current law, section 32949 says nothing in this subdivision shall be construed as creating or recognizing a right to abortion? And the proposed bill, would you agree that there is a substantive change in affirming that prior to 24 weeks gestation, an individual's right to terminate their own pregnancy shall not be infringed upon in this state? Would you agree that's a substantive change to the current law?
Thank you for the question, Senator. I would agree that that is a substantive change, and again, just want to appreciate and underscore the importance of that construction clause right now, stating explicitly that there is no affirmative right prior to 24 weeks.
Yes, Senator Pollock.
Thank you. As a follow-up, Ms. Reed, this is not the first time you've appeared before the Judiciary Committee. As a matter of fact, I think you've been here half a dozen times testifying on other pieces of legislation. And I query to you, in the same spirit as my colleague, why? What's the point? Why bother coming to testify on proposed legislation when another legislature could just do away with it, change it? Why bother?
Thank you so much for the question, Senator. Taking off my ACLU hat, I think from a personal perspective, that it's just really important to honor what Granite Staters are overwhelmingly calling for year after year, and to just understand that people are afraid of what might happen should the state decide to enact a swift an overreaching blanket ban on this care. I mean, there are real material consequences of that, and it's important to keep striving to make sure that the right to bodily autonomy is protected.
Senator Reed, you're all set? Okay, thank you very much for your testimony.
Thank you.
Does anyone else wish to testify who signed up or we didn't say or wants to? Okay, seeing none, we'll end the hearing. Thank you.
Yes.
Okay, all right.
And that's 270. Peter, 270 is yeah.
Motion to go into executive session?
Second. All in favor of going to exec? Say aye. Aye. So we're thinking re-refer senators, but you can give us your input. Reason being,
On Senate Bill 270.
I'm sorry, 270 on the impounded vehicles. So where I do appreciate the fact that if you're a worker and you were accompanying someone, your tools are in the back of the car. On the other hand, we heard testimony from the impound lots. Two of them came in and said they're afraid they're going to give the wrong merchandise out to the wrong people. They'll be liable for it. One, I think it was a state trooper, testified, here's afraid we might give away evidence or something. So they're going to impound the car. They're going to do their, what do you call inspection of goods. Yeah, inventory search. And what happens when they give out the piece of evidence that we need. So they weren't in favor, the other two weren't. We thought we'd re-refer, try to pull it together a little bit. And Senator Murphy might be interested in cleaning up the bill though. So where are your thoughts along those lines for a re-refer or?
I agree that the burden that it put on the operator of the yard where the car was towed is way too high, and the liability for them that it needs some work.
Yeah, so I listened to the hearing. I went home ill that day, but listened from home. And on first blush, this bill seemed like a no-brainer. Like,
Yep.
of course. And had extreme empathy for the gentleman whose work stuff was stuck in the back of that car. But then hearing from the tow operators, like, how do we know who it belongs to? And the process that they have to go through to determine ownership, realize that this is a little bit more complicated than it first seemed.
Okay, so I'm going to make a motion to re-refer the bill. We've had enough, any more discussion? Are we good? All in favor of the re-refer motion? Say
Aye.
Aye. Senator Reed, want to take that?
Yeah, can we move it to consent?
Yes, that's a great idea. All in favor of the consent motion?
Aye.
And then Senator Reed will take that. And that's about it for today. Thank you, guys. That ends.
Motion to
Okay.
move out of exec session.
There you go. That's a good. All in favor?
Aye.
Aye. Yes, have it. We've moved out of executive session. Thank you, Peter.
Thank you for keeping us legal, Peter.